Now, in today's video, we're going to be talking about a case, well, sort of an update to a case that we talked about several months ago. The case is called Wilson v. Hawaii, or in its original incarnation, Hawaii v. Wilson.
Hawaii's High Court will get the last word for now in a gun rights case that went all the way to the U.S. Supreme Court. The justices today declined to consider a challenge to Hawaii's law brought by Christopher Wilson, who was cited for hiking with an unlicensed handgun. Wilson fought the charge, citing a 2022 U.S. Supreme Court decision that brought in gun rights. But then Hawaii's court fought back, calling that decision fuzzy and backward-looking, while arguing that the law did not prevent states from having licensing rules. While the court today decided to end the back and forth, 3 justices said they were willing to revisit the issue later.
And this is known to many people as the infamous Spirit of Aloha case. We recently got a little bit of direction coming out of the Supreme Court. So before we get into that, let's talk about the sort of the background to the case. Many of you remember Mr. Wilson was not a resident of Hawaii the time that the action took place. In fact, it appears that he was a visitor to Hawaii. At that time, and this was in a pre-Bruin environment, Mr. Wilson could not have received a concealed weapons permit in Hawaii. Now, that didn't stop him. Mr. Wilson ended up going on an evening hike, carried a .22 pistol with him, and evidently he and some friends ended up trespassing on someone's private property. That person then called the police. The police responded. Mr. Wilson was arrested for not only trespassing, but for also violating Hawaii's penal code, in as much of the fact that he had a loaded firearm on him without having a concealed weapons permit. Mr. Wilson moved to have the charges, as it relates to the weapons charges, dismissed after the Bruin decision came out. And this case had happened right before Bruin. And he effectively said, look, it was impossible for me to get a concealed weapons permit in Hawaii. There is no methodology that would have allowed me to carry in Hawaii. Therefore, my Second Amendment rights were unconstitutionally restricted, and therefore the law itself is unconstitutional and cannot be used against me in a criminal proceeding. The district court, or the superior court, agreed with Mr. Wilson and dismissed the case. And again, at least as it related to that. Hawaii was not done. Hawaii appeals this, and ultimately it goes to the Hawaii Supreme Court. And the Hawaii Supreme Court reinstates the charges to Mr. Wilson and says that the Second Amendment simply does not apply to Hawaii residents because the Second Amendment violates the spirit of aloha. And this spirit of aloha, I guess in a cosmological sense, is greater than that of the United States Constitution. Okay, guys, I'm going to pause this video for just a second. USCCA, which sponsors these videos, they're doing a giveaway. It's a pretty exciting one right now, but it does end soon. So you're going to want to participate in it really quickly. You can read all about it in the description below this video, but like I said, get on it quickly. All right, let's get back to the video. Mr. Wilson has then subsequently appealed this motion to dismiss all the way to the United States Supreme Court. And on December 9th, the United States Supreme Court denied Mr. Wilson's opportunity to be heard before it. This has made a lot of people upset. It shouldn't. And I'll explain why here in a second. So Justice Thomas wrote not really a dissent to not granting certiorari or not listening to the case. It was more along the lines of he granted an explanation as to why they were not going to hear the case. So this case is not what we call a final opinion. This case is what we call an interlocutory appeal. Keep in mind, Mr. Wilson has not yet had his trial. right? That's still to be had, okay? This is an appeal on a motion to dismiss. So the Supreme Court is effectively saying, look, forget the underlying argumentation as the Second Amendment or anything like that. This case is not ripe for us. If Mr. Wilson is ultimately convicted, then we could go ahead and we could hear this case. So it's simply too early for us to participate in. And in fact, they practically invite Mr. Wilson in the event that he's convicted to come back to the Supreme Court. But what is interesting is that Justice Thomas, in his explanation, takes the Hawaii Supreme Court to task. And this is not all too surprising, since the spirit of aloha argument is problematic, to say the very least. He, of course, does mention the whole spirit of aloha nonsense associated with it, but he really focuses more laser-like on the reasoning that the Hawaii Supreme Court offered. And he said, look, forget the Second Amendment for a second. Your argument, Hawaii, is that you can prosecute this individual for not getting a CCW because he never attempted to get a CCW. And since he never attempted to, therefore he's effectively waived his rights as far as a constitutional argument is concerned. And he says that's absolute and utter garbage, that when we're talking about a constitutional right, there should be no requirement that individuals go through some sort of formalistic application process prior to that right having a vested effect. Now, this is important for a variety of reasons. Many states do have concealed carry restrictions. We can think of New York, we can think of Los Angeles, or California rather, and within California we have jurisdictions like Los Angeles that have worked very, very heavily to slow walk the process. And in the Bruin decision, Justice Thomas, as well as Justice Kavanaugh, in a concurring opinion, said that, simply having concealed weapons permits is not necessarily problematic. The 10th Amendment does allow states to regulate conduct. However, if that regulation becomes too overly burdensome, then that in and of itself could be considered a constitutional infringement. Well, this creates an interesting question, because let's assume, for the sake of argument, the Los Angeles County Sheriff's Department has done an absolutely horrific job of processing CCW applications. It's well documented that it's taken them almost 2 years to process something that requires nothing more than a 5-minute background check. So there's all sorts of, like I said, inherent problems associated with this. Well, if someone wanted to sue the Los Angeles County Sheriff's Department for failure to provide a CCW, it would sort of naturally kind of occur to someone that they would have to first try to apply for a Los Angeles County CCW. But what happens if it's so obvious that the Los Angeles County Sheriff's Department is engaging in an unconstitutional practice and simply not issuing permits? Does someone need to apply and sort of wait 2 or 3 years before they decide that the actions of the Sheriff's Department is unconstitutional? Or has that effectively negated the requirement that they go through the application process to begin with? This sort of explanatory opinion by Justice Thomas may suggest that they could just start carrying a gun. It's an interesting quandary. It's not something that I would recommend that people just arbitrarily do, but there's some nuance to this. Anyways, it's pretty interesting. I think that, they do invite Hawaii to kind of, get on board with the fact that the Second Amendment is not a second-class substandard right. But It's going to be interesting to see what ultimately happens. We'll keep you updated, of course. As always, if you'd like to email me, you certainly can do so at stephen@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.